Welcome to Chapter 5 on Damage Adjustments. Now, as we learned in Chapter 4, courts award damages to compensate the plaintiff for legally recognized harm or injuries which the plaintiff has suffered or will suffer in the future. We will learn in later chapters the rules courts have adopted to measure damages for particular types of injuries and in particular causes of action. For now, it is enough to know that we generally use an award of money as a substitute for whatever harm or injury has occurred. Now, for example, in some cases, as we'll see, the connection between the injury and the damages claimed, the money, will be pretty clear, such as damages in a breach of contract action to recover a debt or to recover a loan. Money is the obvious payment. Or damages for the destruction of a piece of personal property with a known market value. But in other cases, the connection between money and the injury suffered is more tenuous. For example, damages to compensate for pain and suffering or for emotional distress. Now, hospitals may be able to post a pain scale on the wall from 1 to 10, but that doesn't really translate into specific dollar amounts. But I'm getting ahead of myself here. Chapter 4 also identified the basic hurdles that the plaintiff needs to clear to secure a damages award. The fact of injury must be proven with reasonable certainty. The amount of damages must be proven with reasonable certainty. And the damages asserted must have been the natural and probable consequence of the defendant's conduct in light of the policies which made the defendant's conduct actionable in the first place. In other words, the damages must not be remote. In this chapter, Chapter 5, we are going to learn about some basic adjustments to damage awards that can apply whether the cause of action sounds in torts or contract or restitution or it's a statutory cause of action. We have 4 types of adjustments to consider. The first set of adjustments deal with the general problem of the value of money over different periods of time. These adjustments include post-judgment interest, pre-judgment interest, present value adjustments, and inflation adjustments. Time is an issue because we have a variety of milestones, essentially, from the date of the injury to the actual payment of a judgment. We have the date of injury itself. We have a reasonable period of time after the injury has occurred. We have the time when the plaintiff knows or should know of the injury. We have the time when the defendant knows or should know of the injury. We have the time when the extent of damages becomes apparent. The time when the lawsuit is filed. The time when various settlement offers are made during pretrial processes. The time when evidence is presented to the jury, and of course the time when a judgment is actually entered against the defendant. Different legal rules pick up on all of these different time frames for different purposes. So, for example, the question of whether to begin charging interest for the damages that are owing, and if so, at what point in time to begin, and at what interest rate, those are important topics to ensure the plaintiff receives full compensation. Next, we will consider 2 types of adjustments based on the plaintiff's receipt of benefits. A tort or a breach of contract is not all bad news for the plaintiff. Sometimes, the defendant's tort will actually bring some benefits to the plaintiff. And a breach of contract often is beneficial to both parties to a contract. Moreover, particularly in the area of torts, the plaintiff may receive a number of benefits, ranging from private insurance payments to the plaintiff, public benefit programs to pay the plaintiff, gifts, and acts of charity from friends or family. And the defendant may even offer partial payments. Some of these benefits to the plaintiff may be used to offset the damage award, while other benefits are subject to the collateral source rule and may not be used to offset the damage award. Our last set of adjustments reflect application of a general principle that a plaintiff should not be able to recover damages that the plaintiff brought upon him or herself as a result of the plaintiff's own unreasonable conduct. There are two variants of this principle. First, the avoidable consequences rule limits a plaintiff's damages where the plaintiff failed to take reasonable steps to protect him or herself prior to the defendant's wrongful conduct, and that failure led to the plaintiff's injuries being more serious than they otherwise might have been. Second, we have the mitigation of damages rule, which reduces a plaintiff's recovery if the plaintiff has failed, after being injured, to take reasonable steps to mitigate the amount of the damages. As we'll see, the defendant is not the only one with a duty to use reasonable care. Once a tort or breach of contract has occurred, the plaintiff has a duty to use reasonable care to mitigate or reduce the extent of the plaintiff's own injuries. The plaintiff has a duty to mitigate. Well, that's it for now. Off you go to the materials on interest adjustments, and I'll see you back here a little later. So long.